what's the difference between an asset protection trust versus an estate planning trust? Okay. Now, before I continue, I am not an attorney. This is not legal advice. This is just research I've done. Okay. So first, an estate planning trust, which is often simply referred to as a trust, is a legal arrangement that allows individuals, which would be the grantor or settlor, to transfer their assets, such as property, investments, and cash, to a trust entity for the benefit of specific individuals or organizations. The beneficiaries, which are the beneficiaries. The primary purpose of an estate planning trust is to manage and distribute assets according to the grantor's wishes, while potentially minimizing estate taxes, probate costs, and ensuring efficient asset management. There are several types of estate planning trusts, each designed to serve different purposes and provide specific benefits, including a revocable living trust, an irrevocable trust, charitable remainder trust, special needs trust, testamentary trust, qualified personal residence trust, generation skipping trust, and a family limited partnership or family limited liability company trust. In most cases for estate planning, what you're going to see that most attorneys advise that people use is going to be a revocable living trust. And so I'm going to specifically just talk about that in terms of an estate planning trust. This trust allows the grantor to maintain control of their assets during their lifetime while specifying how those assets should be managed and distributed after their death. It can help avoid probate, providing a smoother and more private transition of assets to beneficiaries. So if you don't know what probate is, folks, when you and I can only speak for the U.S., the United States of America, because I'm only familiar with how it works here, but I'm pretty sure it's going to be similar in other countries. So of course, do your diligence on that. But in the U.S., if you don't have a will and testament that specifically tells the government where or who is going to receive your assets upon your demise, on your death, then basically the government has 100% right to seize your assets, and it belongs to the government. So just like in a kingdom where the king owns everything, essentially this democracy that we apparently have is a kingdom because the government controls everything and owns all of your assets, unless you've clearly defined that in a will and testament. Now, if all you have is a will and testament, then that will and testament goes to probate court. Probate court is going to cost your heirs, who are the beneficiaries or the people that you are leaving your assets to, it's going to cost them money, it's going to cost them time, and it could be wrapped up in probate for months or years even, depending on if you have sibling rivalry in your from your children trying to get access to your assets, or even worse, if your children are being contested by different relatives who want to care for your children. So in your will and testament, you define who gets what, but it goes to probate. And then while it's in probate, these things are in limbo, and it's going to cost time and money. And so to avoid probate, you set up a trust, an estate planning trust, and most people will set up a revocable living trust. These trusts can cost anywhere between $500 to $700 for a couple. Now, if you go directly to an attorney on a private level, they might charge $2,000 to $10,000. The resource I'm going to provide later on in the description is only charging $600 for a couple to create a revocable living trust. Now, it's important to note that a revocable living trust, the word revocable means that you can make changes to it, and it's living, meaning while you're alive, you can make changes. So that means if you put your assets inside of a revocable living trust while you're alive, it does not necessarily protect those assets from any litigation or lawsuits, because it's a revocable living trust. A judge could require and demand that you make changes to the trust and award assets to a plaintiff. So it's important to note that you have to distinguish the difference between an estate planning trust using a revocable living trust and an asset protection trust, which we're going to talk about in a moment, which would be done with an irrevocable living trust. So now, while you're living, your assets are in the trust, but they're not necessarily protected while you're alive. So if you're a typical person with maybe a house, a car or two, and some expensive luxury items, a revocable living trust is probably standard for everybody. Your likelihood of getting a lawsuit is going to be low because you're not actively owning and you're not an active entrepreneur where you're expanding your assets and your net worth through multiple properties and multiple assets where you have a risk of someone coming after you aggressively, right? So for most of us, an estate planning trust or a revocable living trust is going to do the job. What eventually will happen is when your time comes and you pass away, then the attorney that's in charge of the trust is going to immediately change it into a irrevocable trust. So the process is instant. From the moment you die, your attorney changes the revocable living trust into a irrevocable trust. They assign an EIN or a tax ID number to it, so then it becomes irrevocable, and then the assets are now protected. Again, it avoids probate, and this is also a way that you can also avoid any certain taxes, especially on properties, because that property, that asset, is not being transferred. The title is not moving from one person's hand to the next person's hand. It stays in the trust. So the trust owns the asset, and then the trustee changes from you to the beneficiary of the trust, who now is the trustee and has access to the assets inside the trust. So if there's any taxes that would normally be in place when you transfer ownership of an asset, because that asset has gained value over time. If you bought a property for $150,000 10 years ago and now it's worth $400,000, there's going to be a capital gains tax that the person that inherits that property will have to pay. But because the trust owns the property, the person that inherits that property is now a trustee. The trust owns the property, and you avoid that capital gains tax. So you avoid probate, you avoid capital gains, protects the assets after your death through a revocable living trust, which is a standard typical estate planning trust. Now, a proper estate planning trust is not just going to include your assets. There's going to be about 7 or 8 legal filings and documents that go into that, including the will and testament go into that, including your medical requests, whether you want to stay alive if you're in the ICU or in the emergency room. So there's a long list of items there. Forgive me, I didn't prepare that list to read to you, but again, on the link I'm going to provide you, you can do all the research you want to learn more about a revocable living trust and take advantage of an attorney service that will provide you that for about $600 for a couple. I think it's $500 for one individual. Okay, before I move on to talk about an estate planning trust or an asset protection trust, before I move on to talk about an asset protection trust, I see you have a question, Wendy, so let me read that out. Wendy asks, my mom has a house in her name, alone, she's 80. I'm not sure how to get beneficiaries and will done since she is now diagnosed with dementia. Okay, her property is worth $800,000. So yeah, definitely, Wendy, you should by this point with that situation have a power of attorney over your mom's assets and estate. If not, then you should be able to get that as part of a medical directive, since she's incapable of caring for herself. And in that case, you should be able to set up a trust for her and then move her assets into a trust. I am not 100% sure if the company I'm going to refer, which is Trust and Will, it's going to be in the link in the description. Just come back later, please, and wait for that so that that you can use the link in my that I provide you, and ultimately they'll be able to answer your questions and see if they can assist you in Canada. If not, then I'll see if I can find another resource for you. All right. Sorry. So let's move on now. So now we're going to talk about an asset protection trust. So an asset protection trust is a type of irrevocable trust designed primarily to protect a person's assets from creditors and legal claims while allowing them to retain some degree of control and benefit from those assets. The primary goal of this type of trust is to shield assets from potential financial threats such as lawsuits, bankruptcy, or creditors seeking repayment. Asset protection trusts are often used as a strategy for safeguarding wealth for future generations or for individuals with high risk professions. So the key characteristics of an irrevocable trust or an asset protection trust is, number one, it's irrevocable. So that means that the asset protection trusts are typically irrevocable, meaning that once assets are transferred into the trust, the grantor gives up control over them and cannot change the terms of the trust or reclaim the assets. Now, there is a caveat to that because you can request and pay the attorney that controls the trust to make changes. So there are changes that can be done. You just can't do it directly. Where in a revocable trust that we just talked about, it's a lot easier for you to make those changes. You don't need the blessing of the attorney to do it for you. You can make those changes, and ultimately the attorney does it, but you don't have to. They don't have to approve it. They do what you ask them to do in a revocable trust, and an irrevocable trust they will have to approve it and accept it and issue it for you. But generally speaking, it's irrevocable. The point of it is that it's not going to change. Okay. Independence. These trusts often require an independent trustee or trustee who is not the grantor. This helps ensure that the trust is not viewed as a sham or fraudulent attempt to protect assets. Duration. Asset protection trusts can have a specific duration after which the assets are distributed to the beneficiaries, or they can be perpetual, continuing for multiple generations. Spendthrift provisions. These trusts may include spendthrift provisions, which restrict the ability of creditors to access the trust assets. This means that creditors typically cannot compel the trustee to distribute assets to satisfy debts of the grantor. Jurisdiction. Asset protection trusts are often established in jurisdictions with favorable trust laws known as offshore jurisdiction or domestic asset protection trust jurisdictions. These jurisdictions may have laws that make it more challenging for creditors to access trusts in assets in the trust. So that is so crucial because there's only one or two states in the U.S. that are favorable for in terms of jurisdiction. But even in those states, even though it is a irrevocable trust, a judge can still penetrate a domestic asset protection trust in most states, and it becomes more difficult in one or two specific states. But when you move jurisdiction out of the United States into certain countries, and so some of them are islands like the Bahamas and Nevis Islands, the jurisdictions and the law changes, and it becomes very difficult, almost impossible or impenetrable for any third party to sue or get access to your assets in an offshore trust, right? Now, for this type of a trust, it's a completely different ballgame. We're talking about minimum $5,000-$10,000 up to $30,000. Again, I'm not the attorney providing the service. I'm going to provide the link. Now, this is going to be a separate attorney group that does the asset protection trust. And again, this is going to be more for so if you are someone who has assets, like millions of dollars of assets that you want to protect, especially when you have real estate assets and businesses where somebody can slip and fall and then they turn around and try to sue you and try to seize your assets. Another way to protect assets that's not mentioned and has nothing to it's separate from the trust, is really by just separating asset and ownership of assets through LLCs. So in some states like Florida, an LLC will protect your assets from litigation. But if you have all your assets in one LLC, then your assets in that LLC could be sued. Where if you separate ownership of assets amongst different LLCs. So, for example, if you're a real estate investor and you own multiple real estate properties, it's a good idea to establish an LLC for each property. So, therefore, if someone slips and falls, if you have 10 properties and someone slips and falls in one of those properties, they cannot sue you for any of the properties that are in control by other LLCs. They can only go after the assets in that one particular LLC. And then, of course, that LLC will protect your personal assets. So your primary residence and other personal assets wouldn't be accessible through, because that LLC protects it. So the LLC will protect your personal assets. It'll separate that. And if you set up a separate LLC for each company, it will then separate the assets and make it more difficult for anyone to sue you for assets in each one of those LLCs, if that makes sense. Now, an asset protection trust is another layer on top of the LLC to add more protection if you're at that level where you need that type of protection. The last key characteristic of the asset protection trust is fraudulent transfer laws, which is transferring assets into an asset protection trust with the intent to defraud creditors is illegal and can result in legal consequences. Asset protection trusts must be established for legitimate estate planning and asset protection purposes. As well as there's creditor statute of limitation. In some jurisdictions, there may be a statute of limitations on creditors' ability to challenge asset transfers to an asset protection trust. Once a certain period has passed, the assets in the trust may be less vulnerable to creditor claims. Disclaimer: it is important to note that asset protection trusts are not foolproof and their effectiveness can vary depending on the jurisdiction and specific circumstances. Laws related to asset protection trusts differ from place to place, and their legality and protection levels can change over time. Additionally, using asset protection trusts solely for the purpose of avoiding existing debts or legal obligations may be subject to legal challenges. Asset protection trusts should be established with the assistance of an experienced legal and financial professional who are knowledgeable about the laws and regulations governing trust in the relevant jurisdictions. They can help you create a trust structure that aligns with your asset protection goals while ensuring compliance with applicable laws and regulations. Again, I am not an attorney, and this information is not meant to represent legal counsel. I will be providing links in the description for legal firms that can assist you, one for estate planning as well as one for asset protection. So make sure you submit your request for an estate planning trust or an asset protection trust below. You'll see that link